Are authors allowed to use public figures to talk about their characters and market their books? Let's talk to everybody's favorite IP and entertainment lawyer, Tony, to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
Readers and authors alike love to fan cast books. They like to find people in real life that represent their characters and use that to then market those books. Oftentimes, these people are public figures, and they'll use photos and videos to say, this is just like my character. This is my character. My character would do the thing that this person did. From a legal perspective, Tony, are we allowed to do that?
So I would say it probably depends on the storyline, the character, and certainly the circumstances under which you're doing that. But I've always been of the mindset of just playing it safe and being very conservative. So I think to the extent that you want to, let's say, create a character that may be loosely based on the themes of multiple public figures or multiple entities, I think that's fine. But if you start doing it as like you're singling out a single person, that's where you may tread into some tricky territory. And that's likely because that could, not saying guarantee, but it could create a false light defamation claim in the eyes of the law. So this is actually a very specific provision in the Lanham Act, the Trademark Act. And it's not to say that this is a trademark scenario, but this is actually a provision that does exist where, let's say you're a public figure or celebrity, and you realize that, let's say your identity has been misappropriated in such a way that a consumer could be led to believe that you either sponsored or endorsed something that otherwise you didn't. That could rise to the level of creating a false light defamation lawsuit. Now, this actually was the subject of a very, very, very important Second Circuit decision from the 1980s, Rogers v. Grimaldi. This is actually a lawsuit that was initiated by Ginger Rogers, iconic dancer from the 1950s that has been alongside Fred Astaire for years in the 1950s, obviously, iconic, actor as well. And Ginger Rogers and Fred Astaire were obviously doing dance numbers all together throughout the 1950s. In 1986, if I'm not mistaken, the Metro-Goldwyn-Mayer, MGM Studios, entered into a distribution deal with a producer in Italy. I forgot Rocco Grimaldi, I think is his name. And they ended up distributing here in the US and globally a film called Ginger and Fred. And it wasn't about Ginger Rogers and Fred Astaire, but it was about two Italian cabaret dancers that impersonated themselves as Ginger Rogers and Fred Astaire. And they had been retired from the industry for years. And there was an opportunity for them to go on an Italian game show that was like really bizarre and apparently a little bit raunchy, but they had an opportunity to win money for the sake of recast or reprising their role as Ginger Rogers and Fred Astaire. So that was the whole premise of that film. Well, of course, because the film is a little bit raunchy and isn't the kind of thing that aligns with the brand or the filmography of Ginger Rogers, she thought that the movie title name and surely the portrayal of her character was something that could create false light defamation, meaning that it could create some sense of consumer confusion where people were led to believe that Ginger Rogers endorsed Ginger and Fred. So this actually ended up going all the way to the Second Circuit, and the Second Circuit said that even though something like false light defamation should be taken into consideration, at the end of the day, the movie had to be evaluated through the lens of the First Amendment as free speech. And basically, they had to create this juxtaposition of where does something fall squarely in being an infringement claim or a false light defamation claim versus being fully protected under the First Amendment. And so the Second Circuit created the Grimaldi test, which basically says that creative works of artistic expression are guaranteed protection under the First Amendment, and that will supersede any trademark infringement matter, or for that matter, any sort of infringement matter that falls within the line of what the Lanham Act prescribes, like false light defamation. So I bring that up as an example because that was a case that has lived on for 30 some years and continues to be assessed and reviewed by a lot of different jurisdictions here in the United States. And obviously, one of the main questions that often comes up in that scenario is also understanding if commercial goods are covered under this Grimaldi test, this unique exception, this unique defense in these types of matters. And so far from what it seems, commercial goods are the kind of thing that are not protected under this Grimaldi test. And I think that we can safely argue that something like a book is a commercial good because it's you could buy them in a bookshelf, you could buy them in, or rather a bookstore, you could buy them on Amazon, on another website. And at the end of the day, it's not like the kind of thing where it's yes, it has a book does have some artistic nature to it, but I think you do have to look at it in its totality as a commercial good. It's no different than a t-shirt or maybe even a dog toy like this, which was actually the subject of a Supreme Court decision from this past summer. This was the center of the Jack Daniels versus VIP products case, where the court also tried to assess if the Grimaldi test applied to a dog toy like this. Is this viewed as an artistic work of expression such that this rendition of the Jack Daniels bottle is protected under the First Amendment? And obviously the Supreme Court basically said, no, it's not. We have to assess this as strictly trademark infringement matter. The design of the Jack Daniels bottle is registered as a trade dress in the USPTO. This is an infringement. We can't look at a consumer good like this through the lens of the Grimaldi test. So to wrap it all up, I think that at the end of the day, when you're talking about a public figure and you're trying to create some type of association with them and a character, and you're using real life public figures to promote your book, that's where I think it does invite a false light defamation. And I'm not sitting here and telling you that the Grimaldi test is going to work for you. It is not a cookie cutter model where it's always going to be the same in every scenario. It's obviously going to be very circumstantial and fact driven, but it is a reality. You could be sued for false light defamation and could invite some type of matter. And I think that the best way to play it safe is to avoid singling out a single person. Again, find different people that maybe share similar traits, and then in the aggregate create all the themes of those characters, those public figures, as one collective character and call it a day. That way, you're not singling out a single person and you're more or less going for theme rather than individuality with a specific public person.
And if you have questions about how you're writing and marketing your books from a legal perspective, Tony's coming back for upcoming episodes, because we don't want to be doing things that everybody else on the internet is doing just because they're doing it and then get in trouble. So drop your questions down below. If you see something and you're not sure, or you just want to be extra sure before you do something, ask us. We are here for you to make sure we're answering those questions. There are no silly questions. If you don't want to be public here in the chat, come to my email, come to my DMs. We want to help you to do this safe and legally protected. So drop those questions down below. And as always, you can reach out to Tony and his social media. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor. And you can check out my entertainment law podcast called End Scene. New episodes drop every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Drop your questions about how you can legally protect yourself while you are marketing your books down below. Tony's coming back for upcoming episodes, and we're dropping daily videos to help you navigate the world of publishing to make this your most profitable and stress-free year ever. We'll see you in those episodes.